Now we are. I got excited. I just got to talking. Thank you. The other thing we talked about the other day, you guys, just a couple refreshers, make sure we're kind of all on the same page here. We ask that you try to eliminate distractions at home. I know there's a lot going on at home. So we've asked that you try to eliminate distractions, tell your family to leave you alone during this time, tell your family to leave you alone when you're studying. I cannot stress the level of commitment that's required from you guys to get through both of these exams. So please make an effort to have yourself in a distraction-free zone. I've had students tell me before that they make a note and put it on the door of their room or their closet and close the door and tells the family, do not enter, mommy's studying, so if that's what you need to do to eliminate those distractions, please take those steps to do that. Turn the TV off. Anybody have their TV on? Turn it off. Turn the radio off. Shut down your Amazon and Facebook and all the other good things that you're looking at. If you find yourself distracted by your phone, put your phone in the other room. If you find yourself constantly looking at, I'm giving you a break every 50 minutes so you can go to the other room and get your phone. But you have to identify what your distractors are. And I need you guys to make that effort to rule those out. Also, as a reminder, the homework assignments, for those of you that I've met, it was nice meeting you. The rest of you, I look forward to meeting you. No deadline on that. Just please remember to do it. I heard from one or two of you this morning. I haven't gotten a chance to respond yet, so I will later this afternoon. But if you sent me your introduction and I received it, I've responded. If you sent it and I didn't respond, then for some reason I didn't get it, so please send it again. Again, a couple of you I heard from this morning. I'll get back to you. Even if I already know you, new class, new introduction. Any questions or comments before we jump back into Unit 2? Okay. Well, it seems like we're ready to go. Y'all ready? Yay. So when we left, we were in the throes of Unit 2. And we talked about some good stuff in Unit 2 that we're trying to get, again, just a fairly basic understanding, help us know various things. And let me go back real quick, just so you guys are listening to me. This is the last slide that we left. Guys, please remember my PowerPoints. My PowerPoints are in the online learning system. So if you feel the need to write down every single word, you may not need to do that. I'm trying to save your hand. I think I figured out all my PowerPoints is like 2 reams of paper. So if you can imagine writing 2 reams of paper, that's copying every single word on my PowerPoint. Did that make your hand cramp a little bit? So know that you have that resource available to you and you don't need to write down every single word. So we left each other on Tuesday and we were talking about good things like fixtures and personal property and what conveys, what goes, what stays when the buyer buys, when they become the homeowner. We also talked about one of our first big fancy words in real estate, things that are pertinent. Why don't you guys remind me in a chat? Let's do this. Remind me in a chat, very simple. If something's a pertinent, what does that mean? Very, very brief answers. I can understand abbreviations. Tell me in a chat. And guys, when I ask for stuff in the chat, this is that class participation that I'm looking for. This is how I know that we're here participating. So if something is a pertinent, Look at you guys go. Yeah, you guys got that. If something is pertinent, what we're saying is what runs with the land. When you buy, you're going to get those appurtenances. When the next person and the person after that, the person after that, the person after that, it runs with the land. It doesn't go with the owner. It stays with the land. So that was our really first big fancy real estate word. A lot more to come. So we left on Tuesday talking about the UCC. This is what regulates personal property that, like, lease to own, right? I don't own it yet. I'm making payments on it. I'm allowed to use it. They'll let me use the water heater, but I'm making payments. Obviously, the seller can't convey something that they don't own. Is that a fair statement? I can't sell you something if I don't own it. So with these, what the UCC does is it protects the creditor, the person that you're paying. It protects them to make sure that they're going to get paid. A lot of times the creditor will file these down at the courthouse at the Register of Deeds. They'll put it on public record. So when a buyer's buying, their closing attorney does a very thorough research of the public record and finds things that could affect the title, the transfer of the property, such as these things on UCC. Everything about recording, why we record, what we record, the act that makes us record, anything you've ever wanted to know about recording is coming up next week in Unit 5. So we'll get more specific into that and the closing attorney's role and responsibility. I understand. Good morning. We need an extra shot of coffee this morning, don't we? So we have one more thing to talk about personal property or fixtures. Does it stay or does it go? And whether or not it goes or stays, that last piece of that conversation is going to be about manufactured. And next, we're going to talk about modular housing. So let's talk about manufactured housing first. And I think somebody asked me about this last class. So here we are. Manufactured or mobile homes are built to HUD standards. HUD is the Housing of Urban Development. It's a government body that regulates housing. We're going to officially meet HUD later in this class. So right now, we just know that they have to be built according to HUD standards. Manufactured homes are going to be titled at the DMV. They're going to be registered at the Department of Motor Vehicles. They're going to have a VIN number. When they are on wheels and they have a VIN number and they're registered at DMV, they are considered personal property. If they're on wheels and a hitch, you can just hook that up to the back of a truck, roll it right off the land, right? It's pretty personal property. Once you take that home, you remove the hitch, you remove the wheels and put it on a permanent foundation, and you cancel the title of the DMV. You have converted it from personal property to real property. You have attached it to the land in such a way that it can no longer be moved. So whether or not a manufactured home is personal property or real property depends. Is it on wheels or is it on a foundation? Does it have the title? Is it registered with DMV? Another type of housing that we have is something called modular housing. Modular housing, they're built in large sections offsite. They're brought into the land on like big sections on the back of a truck, and they're assembled on the land. Have you guys ever been driving down the highway and seen like half a house? That's probably some kind of modular housing on its way to site. So there's this huge warehouse somewhere. Maybe they build it room by room. Maybe they build it floor by floor or piece by piece. But they bring the sections on in the back of a truck, And once it's assembled on site by the builder, it becomes real property. So once it's placed on the land and it's assembled, these are built according to state building codes. We are going to talk about building codes in Unit 6. And once they're assembled on site, you saw one. I saw one on the side of the road the other day on the highway. I thought, oh, that's not good. Somebody's waiting on their home, and it's, I don't know, it looked like they had a flat tire or something. I'm like, oh, that's not good. That's not good. Do you ever wonder where the other half is? It's either on its way or it's already there, right? So manufactured home, is it personal property or real property? It depends. Modular homes, it's going to be considered real property as soon as it's assembled on site by the builder. By the way, this type of building, even in commercial, is gaining in popularity. It's becoming more and more, you know, and there's pluses and minuses to everything, right? So one of the big advantages of this type of building, you're in a big warehouse or a factory. So if it rains, you can still go to work today. That show can still go on. Have you guys ever watched new construction? And when we have a period of like 2 weeks of rain, they got to wait, right? They can't go out and build in the rain. So at least they don't have weather issues while it's being assembled in the factory, in the warehouse. So production can happen a little bit quicker. I know a lot of people say, you know, I don't want my house that comes in on the back of a truck. Well, one way or another, it's coming in on the back of a truck. Is it board by board or is it section by section? But one way or another, it's coming in on the back of a truck. So that's how it goes. Wrapping up personal property and fixtures. Do I have any questions? Okay. Switching gears just a bit. Unit 2 has some just funny different, couple different big topics in it. So switching gears just a bit. And starting on page 29, we're going to talk about an estate and what an estate is. So basically, when we talk about and discuss an estate, we're talking about the amount and the kind of interest that an individual or an entity has in real property. It's the extent that you own it. It's the type of ownership that you have. Basically speaking, we have two types of estates. There's an estate of ownership that we're talking about in Unit 2. There's also an estate of possession. If you're a tenant, you have an estate. You have an interest in the property, meaning you have the right to be there. You don't own it, but you have an estate and you have the right of possession. We get into the tenant-landlord relationship and talk all about tenants in Unit 11. So we'll talk more about that other type of estate. Cool. This is what I need you guys to know about estates. When we talk about an estate, I want you to think an estate is the type of interest. What interest does an individual or an entity have in the property? Very interesting. What will they think of next, right? So an estate is a type of interest. You hear the word estate, I want you to think interest. As I said, we have two types of estates. You know, don't write this down. We're going to talk about all this. This just gives us a nice breakdown. Two types of estates. There's one of ownership that we're going to talk about. The other one is possession. The possession comes in, of course, the possession comes in Unit 11. So just focusing on our freehold estates or our estates of interest. You have a very nice picture for you on page 29 that takes freehold estates, ownership estates, and breaks it down to the different types. And the first breakdown of the different types of freehold estates is going to be whether or not the state is inheritable or it's not inheritable. If something is inheritable, it means it can pass to the individual's heirs when they pass away. If it's not inheritable, then it can't pass to their heirs. So our freehold estates can be broken down, big picture, into two categories: estates of inheritance and estates not of inheritance. The first type of estate we're going to talk about is something called fee simple absolute. This estate is inheritable. This is, without a doubt, the type of estate that we are going to deal with the majority of the time in our real estate career. So like 99.89% of the time. Don't write that down. I just made that number up. But the majority of the time in our real estate career, fee simple absolute is what we're going to be dealing with. This is the highest form of ownership. You own it. You own the structure. You own the subsurface. You own the air above it. You own everything about it. There's no limitations to your ownership as long as you're not breaking any laws. Nobody's allowed to break the laws. We're going to talk about zoning in Unit 6, what restrictions you may have under zoning, protective covenants as well. But other than the laws, there is no limitation on ownership. And when the individual passes away, they're free to do with it what they want. Do they want to pass it down to their heirs? Do they want to leave it to the feral cats of the neighborhood? They're free to do with it whatever they want. It's their estate. They can pass down with it as ever as they choose. Fee simple absolute, what we deal with most of the time. The rest of these types of estates that we're going to talk about. A lot of this class, you guys, I feel in some cases we're teaching you just enough to be dangerous. We're giving you a little bit of knowledge and letting you guys think you have a whole lot of power. If you in your career, your real estate career, you're ever dealing with anything other than fee simple absolute, this is your trigger to know that we need to get an attorney involved. Remember, I am just a real estate agent. I can't handle legal issues. I can't handle legalities. And the rest of these types of estates, if they come up, y'all don't whip out your pre-licensing book and try to tell your buyers and sellers all about them. This is your opportunity to say, wow, I know enough to know, Mr. Seller, that you need to call your attorney. Everybody with me? So we're getting a very basic understanding so we know when we need to call an attorney. So fee simple absolute, we can handle. Anything else, it's our little red flag to get attorney involved. So the first other type, again, broken down in a couple different categories. There's something called a fee simple defeasible, also known as a qualified fee estate. When you purchase one of these properties, you buy with restrictions. Particularly, your restrictions are on how you can use the property. When you get the deed to your brand new home, even before you buy it, by the way, the attorney will tell you this before you buy it. But with these fee simple defeasible estates, you have restrictions on how you can use the land. And it's pretty simple. You break the rules, you lose the property. You know what the rules are when you buy it. But you violate the use, you use the property in a way not allowed, not deeded to you, and you lose the property. In that case, it's going to go back to the person that gave it to you. If that person that sold it to you is no longer with us, it'll go on to their heirs. So with fee simple defeasible, there's a restriction on use. And we have two types of fee simple defeasible. The first type, these names, fee simple subject to condition subsequent. What these say is that the owner, you can do whatever you want to with this property, except one thing. And that one thing you can't do with it. It's deeded. You know when you buy it that you can't do that one thing. You do whatever you want to with it, but you're restricted in the use and that you can't specifically do this one thing. Let's say, for example, the deed says you can do whatever you want to with this property, except sell alcohol. The moment you sell one beer on that property, you've broken the rules and you lose the property. Game over. You sell one beer, you broke the rules. How do they find out? Does not matter. Does not matter how they find out. They found out you sold a beer, you broke the rules, you lose the property. The grantor is the person that sold the property to you. The grantor, where's my highlight? Is the person that sold the property to you. We're gonna meet the grantor more in future units. Right now, let's just understand they're the one that sold it to you. When you break the rules, when you perform that one action that they told you not to do, they will take you to court and the court will issue the property back to the grantor. It will revert back to the person that sold it to you. If that person is no longer with us, then it will go on to the grantor's heirs. So fee simple, subject to condition subsequent. You can do whatever you want to, except one thing. You do that one thing, it goes back to the person that sold it to you. Restriction on use. The other restriction on use is a fee simple determinable. This one says you can only use the property for one purpose. You cannot do anything else. There's only one purpose and one purpose only that you can use this property. Let's say it's deeded that the one purpose, the one reason you can use this property is for religious purposes. You can do anything religious on this property. But the second you do something non-religious on this property, you've broken the rules and you lose the property. It will go back to the grantor. The other thing about the fee simple determinable, the grantor doesn't have to take you to court. It automatically goes back. When you guys see determinable, can you see the word determine in here? Loosely, can we see that word determine? It's already been determined what's going to happen. It's already been determined. It's already been decided. I don't have to take you to court. You use the property for something non-religious. You broke the rules. Property comes back to me. If I'm no longer with us, it goes on to my heirs. Let's look at an example together. This example says the grantor, the person that gave it to you, deeds the land to a school district. The deed says, for so long as the school district maintains a public elementary school on the parcel, and if it ceases to do so, this estate shall end immediately. Is that pretty clear what the one use is? What's the one use? Public elementary school. Could I set up a private school on this land? Could I run a high school on this land? Could I set up a university? It's pretty dang specific, isn't it? What's the one allowable use? Public elementary school. And if you do anything else, this state shall end immediately. The school district has a fee simple determinable estate. If at some point the district does not maintain a public elementary school on the parcel, then the title to the land reverts back to the grantor, or if they're no longer with us, they will go to the grantor's heirs. So fee simple determinable estates, the two we talked about, have a restriction on use. How you can use the property is restricted. Are y'all glad I have you calling attorneys? Yeah. Yeah. Questions on this? Fee simple determinable. Another type of estate is a life estate. Several different types of life estates that we'll talk about, whether or not they're inheritable or not. With a life estate, you don't have a restriction on use. You can do whatever you want to with this property. With life estates, your restriction is on time. The restriction is how long you own the property. Life estates are sometimes referred to as partial estates because they don't last forever. Only asked for a little bit of time. Yes, do you have a question? Maybe an accidental unmute. Let's see. Y'all beware, I got Zoom power. I can mute you, unmute you, turn your camera on, and I got all sorts of power over here. I don't know half of my power. So our life estates, there's a limitation on time. Again, no restriction on use. You do whatever you want to with it. Your restriction with these is on time. Now we have 3 different types of life estates. The first type of life estate is called a conventional life estate. A conventional life estate is one that is not inheritable. Again, if we go back to our picture on page 29, we see that our conventional life estate is not inheritable. The reason being is because the owner of a conventional life estate owns it for their life. And when their life is over, that estate is over. So it can't be passed down. When the life estate is over, when the life tenant passes away, this estate is either going to go back to the person that gave it to you, back to the grantor, or it's going to go on to a named third party. So the deed is going to say, at the end of this estate, at the end of your life, this is where it goes. Question comes in, is this common? I don't know. I've never dealt with it. I don't know how common it is, but obviously it's a thing because we're talking about it. And when we come across this, what are we going to do? I'm going to call our attorney. Yep. This just got out of our realm really fast, you guys. So a conventional life estate, we have the life tenant owns it for the length of their life. When their life is over, they no longer own the life estate. It either goes back to the person that gave it to you, or it goes on to the named third party. We'll talk more about those roles in just a second. Yes, ma'am. Adriana?
So for
Hi.
the first, yes, the first property that we were talking about that you said was inheritable. In the event that that the person who owns the property does pass on and they don't have any, like certain, instructions as to where the property would go in the event of their death, then where does that property go?
That's a great question, and that happens more often than what we realize. Maybe the state can find heirs. Maybe the state just has to take control of the property. We're going to talk a little bit more about that in Unit 5. So what happens if somebody passes away that owns property and doesn't have a will or doesn't have heirs? That happens. If we don't get anything else from this unit and Unit 5, if y'all don't have a will, make an appointment and go get one. Because if something happens, I mean, we hate to have this conversation, let's face it, but if something happens and you don't have a will, do y'all want the state to come take your property? I doubt it. So We will, thank you, and that's a great question. And we're gonna hit on that also in unit 5, I think it is. So conventional life estate. The other estate we have that's not inheritable, again, we only have the 2 on page 29. The other estate we have, life estate we have that's not inheritable, is called the marital life estate. We're going to talk about the different forms of ownership next. So what ownership looks like when married people, what ownership looks like when people aren't married. With the marital life estate, in this scenario, when this kicks in, if an individual buys property before they're married, they're single, you're young, you buy property, and then you get married. One thing we're going to learn in the next section is North Carolina is a spousal state. And because we're a spousal state, when the person that bought the property before we were married passes away, I'm entitled to some of the property because we were married at some point during that ownership. And how much of that property I'm entitled to depends on how long we were married. The yardstick of how much is mine is dependent on how long we were married. So you own property, you get, now I don't like that scenario. Somebody owns property, we get married, that somebody passes away, I'm entitled to some of it because it's a spousal estate. How much am I entitled to? It depends on how long we were married. Heirs, all that, yeah, they'll get some too. But because it's a spousal estate, I'm going to get some. Again, talking about the different forms of ownership. Next. Marital life estate. Think of the marriage, the length of marriage as the yardstick to determine what's yours, to determine how much of that property is yours. The last life estate we have, this one is inheritable. This is called a life estate pour autre vie. You guys know you were getting a French lesson today? Pour autre vie means for life of another. And in a life estate pour autre vie, you have the life tenant, you have the person that owns the property known as the life tenant, and then you have this measuring life. The measuring life doesn't own the property. They have no interest, they have no rights. The measuring life simply serves as the yardstick to determine how long the life tenant owns the property. So in other words, what I'm saying is the life tenant owns the property for the life of another. And when that other life is over, the estate is over. It's either going to go back to the person that gave it to you, or it's going to go on to the named third party. Measuring life is just serving, the life of the other is just serving as the yardstick to determine how long the life tenant owns the property. There is a really good example of this. If you guys will look with me in your books at the top of page 33. Because I know I hear you guys. I hear you. Why in the world would somebody do this? I hear you. So let's look at an example. I like this one. Austin owns a fee simple title to the property. He conveys a life estate to his brother Carl for the life of Carl's daughter, who has a major disability. Carl has the right to enjoy the ownership of the property. He's the life tenant, but the daughter is the measuring life. Should the daughter die, Carl's estate will terminate, revert Austin or Austin's heirs. The daughter never has nor never will have an ownership interest in the property. To me, it's pretty clear Uncle Austin just wants to make sure that his niece has a roof over her head, she has a safe place to live. And one way that Uncle Austin can guarantee this is to give a life estate to Carl, but he doesn't want Carl to own the property forever. He only wants Carl to own the property for the life of Carl's daughter. And that would be an example of this pour autre vie. Uncle Austin's a good uncle, isn't he? Wants to make sure his niece is taken care of. If Carl dies, it can go inherited to Carl's heirs. The estate can be inherited until the daughter dies. So we can inherit it, it'll be in the will. If these are set up, by the way, wills are created because we need to know what happens. And attorneys are involved, so attorneys know that we need to do wills. So life estates have a restriction on time. You're limited on how long you own the property. Real quick before break, finish this little piece up. We've been talking about either goes back to the grantor, to the person that gave it to you, or it goes on to the named third party. Those people have official titles. So if it's a remainder interest at the end of the life estate, it's going to go on to the named third party. The deed is going to say, at the end of this life estate, the property goes to third party. The other scenario is it goes back to the grantor or a reversionary interest. You guys see the word reverse in there? Reversionary interest reverses back. It goes back to the person that gave it to you. If for some reason nobody's named, then the default is the grantor. The default is the reversionary interest. Questions? Okay. Let's see, on page 33, Austin or his heirs. So if Austin's no longer with us, then it would go back to Austin or his heir, to his heirs. Again, it's got to be spelled out in the deed. What happens at the end of this estate? Again, we got attorneys involved, so they're taking care of all that. Let them handle that. Okay. All right. My coffee cup tells me that it's break time. So let's take 10. We come back. We're going to keep going in unit 2. I forgot to say something earlier. It looks like mostly we're good, but I think I need a few of you to rename yourselves. One of you is in as a phone number. Looks like other than that, we're good. So yeah, if the phone number can rename yourself, or maybe you've already talked to me, I don't remember. Just make sure I know who you are, please. You can send me something. Okay. All right, we're back. So cameras are on and I can see you. Please remember it's twofold. I can't give you credit if I can't see you. So cameras are on. All right, everybody ready? I'm gonna take a screenshot. Everybody say money. All right. Welcome back. So again, this is just putting names. We were talking with the life estate. Either it goes on to a named third party or it goes back to the grantor. So that named third party has a name, that back to the grantor has a name. And that's just what we're doing here is naming the remainder man or the reversionary interest. The reversionary, it reverses back to the grantor. If the grantor is no longer with us, it'll go on to their heirs. The other thing with these, with life estates, as we've mentioned, you always have a life tenant. The life tenant is the one that owns the property. Maybe they own it for their life in a conventional life estate. Maybe they own it for the life of another in the life estate for Ultra V. But it is important that we understand that the life tenant does own it. So while they own the property, they can do whatever they want to with it. It's theirs. There's no restriction on use. There's no restriction on what they can do. There's just restriction on how long that they own it. So if they want to earn an income, if they want to rent it out to tenants and collect rent, if they want to plant an orchard or a garden or whatever, they can earn profits from it. They can use the resources on the property. They're not allowed to have waste, though. They can't destroy the property because remember with these life estates, somebody's waiting in line for the property after them. So they can't waste or destroy the property. That person waiting in line could go after them as in a court of law because they destroyed what will be theirs, their future ownership. They own it, so they get to pay taxes and homeowners insurance and special assessments, all of which taxes, special assessments, and homeowners insurance we're talking about in this class. So understanding the rights of the life tenant, they get to do anything while they own it that any other person would do when they own it. They're just restricted on how long they own it. Another type of estate that we're going to see even less commonly than the rest of these we've talked about, so we're just going to hit on this briefly, is something called a homestead. This is just a legal life estate. It serves as the family home. It's been dedicated as the family home. With these homesteads, they can be protected from most creditors. I mean, they still have to pay property taxes. Property taxes are coming up in Unit 3, but they may have some protection. Some states, they may have a tax advantage. If you want to know about homesteads, tax advantage in North Carolina, you can look at page 34. That's about all we're going to say about homesteads. We're going to have one more blip about it in Unit 3, I think, and then we're moving on. Nothing else to say about homesteads. Questions on a freehold estate. Freehold estates are estates of ownership. And thank you for telling me you're back from break. We have taken attendance. Okay. Kind of switching gears one more time in this unit. We've talked about estates. We've talked about the interest. Now let's talk about the ownership. The estate tells us the rights that are to be conveyed, the interest, how long you own it, what you can do with the property. Types of ownership defines who holds the title and what form of ownership that they have. So there's two types of ownership. We're going to talk about severalty and concurrent forms of ownership. So the first type of ownership is severalty. This is the easy one. Sole owner, one person or one entity. Maybe it's a corporation or an LLC, for example. Sole owner means there is only one person on the deed. There is only one person entitled to this property. Again, it may be an individual, it may be an entity. When I see severalty, I know this word is weird with this, but when I see severalty, I see sever. So maybe they've severed everybody else away and it's the last man standing, right? We're going to see examples of that in just a second. Maybe try to restart, Brittany, log out, log back in. Sometimes that may help. So severalty is a sole owner. The other type of ownership that we have is concurrent forms of ownership. And as you can see, we have a couple different types of concurrent forms of ownership that we're going to talk about. Concurrent forms of ownership means that two or more people own the property. Maybe it's two, maybe it's 2,000. It's more than one. Two or more own the property. So we're going to talk about our different forms of concurrent forms of ownership. And first up, we have something called tenancy in common. A couple things to understand about tenancy in common. The ownership interest is usually unequal. We're not going to own it 50-50. We're going to own it 49-51 or 60-40 or 70-30 or whatever we agree to. You can have as many owners as you want, but we each have an unequal share of ownership. Each owner has an undivided interest that they can sell or convey or transfer. You don't need permission of the other owners to do so. When a tenant in common passes away, their interest goes to their heirs. Again, attorneys create tenancy in common. And good attorneys, when they create this tenancy in common, are going to list each tenant's heirs. So we know that when a tenant passes away, it goes on to their heirs. Another tenant passes away, it goes on to their heirs, and so on and so on. These are the estates that can get really complicated really fast. By the way, this section is another call your attorney section. Teaching you guys just enough to be dangerous. Seriously. So let's look at a picture of tenancy in common and passing to heirs. You have two people that buy a home. They decide we're going to buy this 60-40. We go in together, we buy the 60-40. The owner with the 60% interest passes away, and their 60% interest is divvied up. In this case, they have two heirs. So their interest is passed to their two heirs. The person that owned 40 still owns 40. You guys see that? Their interest didn't change. Their interest didn't change. The only thing that changed was the interest of the owner that passed away. I tend to think as an example of who might do tenants in common, just as an example, might be like people going into business together. I've always heard if you're going into business with somebody, never go 50-50. Because if you have a tiebreaker, who's going to settle that, right? So you need somebody with like one more vote. So maybe you have people going into business together. They need to buy property, residential, commercial, doesn't matter. And let's understand this about any of the types of concurrent forms of ownership. What we're talking about, your 60%, 40%, that's your ownership interest. We're not dividing the land. We're not saying this is your 60% that you can go on and this is my 40% that I can go on. The 60-40 we're referring to is our ownership interest. In other words, if we were to sell this home, how are the proceeds going to be divvied? I'm going to get 60% of the sale. You're going to get 40% of the sale. Thank you. So tenant in common. passes away, ownership goes to heirs. Another type of concurrent form of ownership is called a joint tenancy. Now, in joint tenancy, the ownership interest is usually equal. I'm going to own it 50-50. One common feature of a joint tenancy, to be joint tenants, we all have to appear on the same deed, the same document. We all have to be there at the same time when we purchase. We're all going to the attorney's office all at the same time, all signing the same document. We don't have somebody coming in tomorrow to sign. We're all taking title together. We're all on the same deed. Joint tenancies, tenancy can be equal shares. And with joint tenancy, there may or may not be something called right of survivorship. Right of survivorship. Let's say you have two people that own property, 50-50. What right of survivorship says is that when one owner dies, their interest automatically goes to the other owner. I don't care what this person's will says, makes no difference to me whatsoever. Joint tenancy, right of survivorship says that when this one passes away, the interest automatically goes to the remaining, who now owns it in severalty. They have severed the other owner. So they went from joint tenancy, this one died, now they own it in severalty. This is what you guys need to make sure you make a note of. How you answer joint tenancy questions depends on what section of your exam you're in. If it's a national section, right of survivorship is automatic. Right of survivorship just happens. In North Carolina, right of survivorship is not automatic. In North Carolina, that right of survivorship has to be created. It has to be added. The attorney will do that. The attorney will generally ask, if something happens to you, what do you want to have happen to your interest? So in North Carolina, it's got to be added. An example of who might do a joint tenancy, again, anybody can do tenancy in common joint tenancy, but just as an example of who might do joint tenancy, might be unmarried people who are buying property together. We're getting to married people next. So we're not married, but we want to buy a house together. We could take joint tenancy, and in North Carolina, we could choose to add right of survivorship. This is what our picture of right of survivorship looks like with joint tenancy. Two people own, 50-50, one dies, automatically goes to the remaining owner, who now owns it in severalty. Again, I don't care what this person's will says. Joint tenancy will override a will. This is the person's will that matters. Because now when this person passes away, now we need to figure out what to do with the estate, what to do with the property. Let's see, I see a hand. Yes, is it Ariana? Yeah.
Yes, ma'am. So basically my question is in the event that they, choose not to apply the right of survivorship to their, contract, does the will then come into effect?
Yes, so if we don't have right of survivorship, then it will go to the heirs. Yep.
Okay.
Thank you. So right of survivorship, it automatically goes. Without right of survivorship, the will have to spell that out. What do you want to have happen to your part of the property? So joint tenancy, let's look at another example. We'll use the example of unmarried, which again, we're talking about married next. But we're using the example of joint tenancy with unmarried. But here's another example for us. Let's say a sister and a brother purchase a beach cottage. They take title as joint tenants and they add with right of survivorship. So brother, sister own a property with right of survivorship. The brother dies. His estate in the beach cottage automatically passes to the sister. She now owns the property in severalty. I don't care what the brother's will says. Is the brother married? Does the brother have kids? Doesn't matter. Joint tenancy says when one dies, the interest automatically goes to whoever's landing. Now the sister owns it in severalty. As we mentioned, one of the common things about joint tenancy, they have this idea of these required unities. And what we mean by this is what we were saying, that everybody is taking title at the same time. Everybody's on the same deed. Everybody's on the same document. We all show up at the attorney's office together. We take title at the same time. We have same interest, unity and interest. And again, you guys, this unity of possession, when we talk about your 50-50, we're not drawing a line down the middle of the property and saying, this is my half and that's yours. What we're talking about, I have just as right to access the entire property as much as you do. Does anybody in here grow up with siblings, specifically that you had to share a bedroom with? Anybody had to share a bedroom with us? Bless y'all's heart. I'm an only child. I didn't have these struggles, but those of you that had to grow up with siblings and share a bedroom, I hear sometimes you guys would get in fights, and some of you would take tape and draw it down the middle of the room and say, don't come on my side of the room. And anybody have those fights with your siblings? That's not how joint tenancy works. You cannot draw a line down the middle of the property and say, this is my half, you can't come on my half, and that's your half, and I won't come on yours. I have the right to access every square inch of that property. When we talk about that 50-50, we're just referring to your ownership interest. If we were to sell this property today, I get 50% of the proceeds, you get 50% of the proceeds. So these common unities are what we see with joint tenancy. So let's talk about a what if scenario. What if you have a property that's owned by 3 or more joint tenants? One owner conveys. So let's take what we're looking at. Y'all like pictures? I like pictures. Words don't mean so much sometimes, do they? So I like pictures. So let's say you have 3 owners, and let's pretend that those are equal shares. I like pictures, but I don't draw. So, okay, let's see. Let me change my color real quick so you guys can see that. Okay, so let's get real creative and call our 3 owners A, B, and C. A, B, and C buy properties as joint tenants. They all own as joint tenant. A, B, and C were there all at the same time when we took title. We were all at the attorney's office. A, B, and C are on the deed together. We have our required unities. We all own 33 1/3% interest. Joint tenant in every definition that we know. Let's say B wakes up one day and B says, I've absolutely had it with you guys. I'm fed up. I'm not doing this anymore. I'm going to sell my interest to D. Can D be a joint tenant? Can D come in as a joint tenant? You shake your head, yes or no. I can see you. Can D come in as a joint tenant? And the answer is no, because D wasn't there when we took title. D wasn't there on day one. D is the new guy. Everybody with me? So the new guy can't come in as a joint tenant because of those unities, because they're not on that same title, that same time. So now what would happen when B sells to D, D now comes in as a tenant in common with A and as a tenant in common with C. Did anything change in the relationship with A and C? Weren't they still there at the same time? Weren't they still the original owners? So now we have different forms of concurrent forms of ownership on the same property. Before your head explodes with the what ifs, call your attorney. This is where we end. Because this just got really complicated really fast. What happens when A dies? What happens when D dies? What happens if C sells? This just got really complicated really fast. What you guys need to know is that the new guy can't be joint tenants. the new guy, because the new guy didn't come in, they weren't one of the original. So if the property is owned by 3 or more joint tenants, one owner conveys their interest. The new owner comes in as tenant in common, the other remain joint tenants. Interest will remain the same. Yes. Yes. So B sold their 33 1/3 interest to D. We all still own the same interest. Good question. Thank you. Questions on joint tenancy? I got a nice little summary chart for you guys in just a second too. Kind of piece all this together. Good. I like pictures. It's one thing you guys are going to learn about me. If I get an opportunity to show you a picture in the book or attempt to draw something for you, I'm not an artist. There it is. I'm going to put that out there. But my Zoom tools can help a little bit. Top of page 38, we talk about how tenants and commons and joint tenancy, TIC or JT, how tenant and common and joint tenancy ends. Voluntarily agreement, so we could wake up one day to just decide to sell the whole property. Maybe you want to sell your portion. Maybe all of us decide that we're done with each other. Could also lose the property by court order. We're going to talk about why the court may take the property. We'll get to that in Unit 5. The third type that we have of concurrent forms of ownership is the form of concurrent ownership that is set aside specifically for people that are married when they buy property. And when you buy property, when you're married, you're already married, you're married first, and then you buy the property. More than likely, you will buy its tenancy by the entirety. Tenancy by the entirety is set aside only for people who are married when they buy. Please hear that. The act of getting married does not create a tenancy by the entirety. So what if you own property and then get married? That's where that marital life estate kicks in. If you're married and then buy property, the most common way to take title is tenancy by the entirety. Understand this is the default, the most common, but married people could choose to take joint tenancy or tenancy in common. I don't know why they would, but they could. North Carolina is a spousal state. And what I mean by that is it takes 1 to buy, but 2 to sell. So if you're married, you could buy property without your spouse. How do you think your spouse is going to feel when you come home and tell them that day that you bought a house without their knowledge? 1 to buy, they don't care. Cool. 1 to buy. But when you go around to sell that property, we need both because we're a spousal state. I got my license in 2008. And the story I heard about 1 to buy, 2 to sell in my pre-licensing class resonated with me and it stuck with me. And I still remember it quite well to this day. So 1 to buy, 2 to sell. Gentleman purchases a condo for his mistress. That relationship runs its course. They break up. Gentleman goes to sell the condo. And the attorney says, what? We need your wife to sign off on this property that she knew nothing about. What does gentleman say? Whoa. You guys with me? He bought it without her, no knowledge whatsoever. Now he wants to sell it. His wife has to sign off on it. That's what we mean by a spousal state. What is he to do? Well, he either needs to fess up or get a tenant or, you know, you don't have many choices. 1 to buy, 2 to sell. I guess the moral of this story is rent an apartment for your mistress or mister. Don't buy on property. So Tennessee by the entirety, 1 to buy, 2 to sell. With Tennessee by the entirety, right of survivorship is automatic. 2 people are married, they own property, and something happens to one, the interest automatically goes to the remaining spouse. Tennessee by the entirety has those same unities that we saw in joint Tennessee. Yeah, and I get questions like, what about prenups and what about free trade agreements? We're not getting into all that. Do prenups exist? Are they a thing? Of course. That's again out of our realm. Tennessee by the entirety can be terminated by death, right of survivorship. That would terminate the Tennessee by the entirety, and now the remaining spouse owns it in severalty. Divorce, that could separate the ownership interest. Once we're not married, if we both still own the property, we need to go tenant common or joint Tennessee or just sell the property. Or mutual agreement of the spouses, which means we both agree to sell it. What if the owner who bought dies and it's financed, but the spouse is not on the financing? Most of the time, if you get a loan with just one spouse, most of the time the lender will require both names on the deed. So that's not going to excuse you from paying that loan off. Most of the time. What about if somebody leaves a will for an heir? Right of survivorship says, when one dies, the interest automatically goes to the remaining spouse. I do not care what this person's will says. Now, this person's will matters, right? Because when this person dies, now that's going to tell us what to do with the property. But right of survivorship overrides a will. Look at an example together. Spill my coffee. While engaged, if you're engaged, are you married? Not yet, you're close. If you're separated, aren't you still married? There's only 2 answers to the question, are you married? You either are or you're not. So while engaged, Tom and Nancy purchased a home in Walkertown. They're both named as grantees on the deed. They marry 1 month later. Understand that the act of getting married does not create the Tennessee by the entirety because they were not married at the time they took title. So when they got married, let's just pretend they took it as joint tenants. When they get married, they're still going to be joint tenants. Their ownership is not going to change because they're now married. If joint Tennessee and Tennessee by the entirety sounds similar to you, I would agree completely. There are some people that may say that joint Tennessee was meant to mimic Tennessee by the entirety for unmarried people. So if you have 2 people that want to buy and they're not married, they can have the same ownership interest as if they were. North Carolina is a spousal state. 1 to buy, 2 to sell. Even if they own first and then you get married, you still have an interest. So you still have to sign off on that. That's that marital life estate. Y'all think long and hard before you get married and before you buy property. There's a lot to take into consideration. Here's your free advice for the day. So joint Tennessee, again, is meant to mimic Tennessee by the entirety for those that are unmarried. Y'all don't worry about doing anything with this. I have this slide pulled off separately for you in the online learning system. So you can just go look at this one slide instead of finding it in the PowerPoints. I think it's still there. I'll look to be sure. But this just gives us a nice side-by-side comparison of the 3. I think this is beneficial. I think it's okay now, but I think it's going to be more beneficial in like 2 months from now when you're trying to review the ownership in joint Tennessee and Tennessee in common. So let me just make sure I have the chart. I made myself a note. I'll check on that, make sure I still have it in there. But this just kind of gives us a nice side-by-side comparison. Guys, telling or advising people on how to take title, advising people to go Tennessee by the entirety or joint Tennessee or Tennessee in common is the attorney's job. You and I cannot advise people on how to take title. So why do we go through this whole exercise? If you're helping buyers buy that aren't married, our little red flag needs to go up to have them talk to the attorney so the attorney can explain this to them and tell them, advise them on how to take title. I had a couple, I helped buy a house. They moved down from New York. He got a job down here. They weren't married. He got a job down here. He asked her to come with him. She said, okay. He said, I'll give you a choice. Either buy you the ring or I'll buy you the house. And she said, oh, the house for sure, no doubt. So they came to North Carolina to buy a house. I knew they weren't married. Once we went under contract and the attorney started doing their thing, I did not whip out my pre-licensing textbook and begin to explain joint Tennessee and Tennessee in common to them. I set up a conference call with our closing attorney during their lunch break. The whole phone call took about 7 minutes. And the attorney explained to them joint Tennessee and Tennessee by the entirety. And I wasn't privy to the conversation, but I have a feeling it went something like, when something happens to one of you, what do you want to have happen to your interest? Do you want it to go to the remaining person, or do you want it to go on to their heirs? If you want it to go on to your heirs, we'll do Tennessee in common. If you want it to go to the remaining, we'll do joint Tennessee. And because we're in North Carolina, we're going to add right of survivorship. It's not my job. That's getting out of my lane. So advising people on how to take title, we need to get them to their attorney. That's a CYA. Call your attorney. Yes. Annette.
I had to unmute myself. So you're basically saying, regardless on your situation, if you're married prior to buying a house, whether you have a will or any kind of legal documentation, that the right of survivorship is going to override anything once you pass.
If you're Tennessee by the entirety, yes. Now, again, you guys, there's prenups. Of course, there's prenups, there's pre-agreements. We're not getting into all that. So could a married couple set up a prenup and say, when I die, this property's yours? Sure. But we're not getting into all that. So keeping this simple. North Carolina is a spousal state. There's all the what ifs, right? So this is what we need to know. And again, this is one of these teaching you guys just enough to be dangerous, but understanding what that Tennessee by the entirety means.
Okay.
I told you there's some weird stuff in Unit 2, okay? Okay. Switching gears for the last time in Unit 2, kind of big sections in Unit 2. So the last big switch we're going to have, we're going to talk about some hybrid forms of ownership, also known as common interest. The reason that they are hybrid forms of ownership, because usually we have elements of one or more different types of ownership. One thing that's very common in a common interest community is we usually see a homeowners association. We're going to talk about homeowners associations, but basically homeowners associations are going to be responsible for maintaining the common areas, the exterior. There's probably dues. Maybe they're monthly, quarterly, or annually. If they need to do major repairs in the community, like, I don't know, replace the roofs or repave the parking lot, they may issue a special assessment, charge the homeowners for that parking lot repavement. So we have a couple different types of hybrid forms of ownership or common interest forms of ownership. And the first type we have are our condo owners. condominiums. Condo owners own space. Condo owners own from the walls in. They don't own the exterior. They don't own any of the land. They don't have land below or air above. Because they only own space, we can stack condos. Condo owners own, they always say, from paint to paint, or sheetrock to sheetrock, or wall to wall. And with condo owners, the common areas are going to be managed by the homeowners association. They maintain them and manage them. However, the common areas are owned by all of the owners as tenant in common. So we have two forms of ownership here. We have the ownership of the condo itself, and then we have ownership of the condominium complex of the whole community. So we own the individual unit, maybe in severalty, Tennessee by the entirety, however we own it. But we all own the common areas as tenant in common. Some condo complexes may also have exclusive rights to limited common elements. So think, for example, a reserved parking space, or a reserved garage, or a reserved storage unit. You have exclusive rights to that element. When we talk about common areas, why don't you guys share with me in a chat? When I say common areas, what do you think of? What do we mean by common areas? I can tell we're in spring. Over half of you said the pool. Yes, we know where we are. We're lounging by the pool, aren't we? The pool, absolutely. There's the gym, the clubhouse, the party room, courtyards. Is there a dog park? The parking lot? Is there a playground? A breezeway, a lobby? Absolutely. Elevator? If you have an interior elevator, absolutely. You guys got it. Laundry area? Yep. Dumpster? Absolutely. You guys got it. The common areas are things that we can all use. And the reason we get to use them is because we own a unit in that complex. Does that make sense? So because we own a unit in that complex, we have the right to use the pool and the clubhouse and the laundry room and all that other good stuff. So condo owners, the common areas are managed by the HOA, but they're owned by the unit owners as tenant in common. In North Carolina, we have something called the North Carolina Condominium Act of 1986. This is the act that dictates new construction condominiums. And what I mean by that is never before lived in. Somebody's got to live in them first, right? And that person that lives in them first has some rights. They're protected under the North Carolina Condominium Act of 1986. And what this act says is the developer of the condominium has to have everything finalized and on record before they can sell the first unit. We can go under contract with preliminary information, but everything's got to be finalized and recorded before we can sell the first unit. Let me ask you guys a question. Is it a fair statement to say that a buyer deserves to know what they're buying? Is that a fair statement? I would think so. So if you're buying a condo, don't you have a right to know the final plans, the final bylaws, the final plat map? And that's what this rule says. That's what this rule protects. The developer has to have everything finalized before we can close on the first unit. If we go under contract with a preliminary and the preliminary changes, the developer needs to, of course, notify the buyer that's under contract, but give them the opportunity to walk away if they don't like the changes. You can't make somebody commit until you have things finalized. That sounds fair, doesn't it? That's what this act is doing. It's protecting the buyers with this new property. The developer has to provide a public offering statement. That public offering statement just discloses the ownership of the condominium, how it's structured, how it's managed, kind of the ways of the land, if you will. And the other thing that the act does, again, this is all about new construction, never before lived in. If you're the first one to buy, the buyer has a 7-day recession period. Let's talk about what a recession period is. If you're rescinding your contract, you're taking it back. If you put down any deposits, you'll get your money back. The buyer in a brand new construction condominium has 7 days from contract to rescind their contract, to back out and get their deposits back. This is to protect the buyer. Some developers have a reputation of that shady salesman. So this gives the buyer time to review their contract, make sure they're good with it, the covenants, the bylaws, all that information, the public offering statement, all that stuff provided to them. It gives them time to think about it. It gives them time to take the contract to their attorney if they want and have them look it over. This 7-day recession only applies to new construction. So once somebody has bought it once, that 7-day recession period is over. This is only new construction. They would get their deposit backs, absolutely. So the idea of rescinding, you take your contract back. If you put down any deposits, you get your money back. The idea of the 7-day recession, it puts both parties back in the position that they were in before we went under contract. Nobody's harmed, nobody's out anything. We both go about our lives as if this never happened. It puts us back in our original position. The act does mention a few things for resale. Resale, once somebody's owned it once, it's considered a resale when they go to sell it. There is no right to cancel. But the developer should still provide the pertinent information about the property. Now that all the bylaws and plat maps and covenants are finalized, most of the time we can find those at the Register of Deeds. They're public records. The developer should point people in the right direction or provide them a copy. They still have a right to know what they're buying, even though they're a resale. The offering statement is as well. Say more about that. So condominiums are a form of hybrid ownership. We've got two different types of ownership in here going on, don't we? Somebody owns the individual unit. We all own the common areas as tenants in common. That's what we mean by hybrid. Another type of common interest community we have is something called a cooperative ownership. You may have heard this referred to as a co-op. Co-ops, you don't own property. You own stock. You purchase stock, and while you own that stock, it gives you the right to live there. The stock is personal property. The rules and restrictions on selling your stock or transferring your stock have to be spelled out in the rules, the laws. But there's a corporation that owns the building. They sell you stock. That stock allows you to live there. That's what this proprietary lease means. I'm going to talk about timeshares. Yep. So nope, we're not talking about timeshares yet. We don't see many co-ops in North Carolina. I've heard of one in Charlotte, but I can't tell you a name and I can't even verify that it's a real deal. Typically where we see co-ops, think of our older, bigger cities like New York City, Philadelphia, Boston. A lot of those buildings may be set up, may be designed as a co-op. Again, you sell your stock, you got to move. That's your ticket to live there. You don't own property, you own stock. Another type of ownership is townhome ownership. Townhomes and condos are not the same thing. Townhome owners own a little bit of land. Townhome owners own the air above it. Townhomes cannot be stacked like a condo is. Townhomes are sometimes referred to as row houses because they're side by side. Maybe you have 2 connecting, maybe you have 20. And a very common feature of townhomes is a party wall. Let's say this, you see these 2 units right here, 2 garages, 2 doors. Let's pretend this is their wall. The party wall means that this wall they share. On one side of the wall is my home. On the other side of the wall is your home. It's a big party, right? We share that wall. Townhomes are owned and managed by an HOA. Remember we said with the condo, they're owned by the condo owners. They're managed by the HOA. Townhome, there is no ownership of the common areas by the occupants. In a townhome, the common areas are owned and managed. And because townhomes are not condos, they're not covered under the North Carolina Condominium Act. They have no recession. They have no opportunity for new construction to back out. It's a different ruling. The Condominium Act only covers condos. Again, managed by the HOA, there's going to be dues. If they decide it's time to redo the roofs or the vinyl siding or whatever, they'll put out a special assessment. All the homeowners get to pay their fair share. Do they own subsurface right? Yeah, you see their land? That's their land right there. So they own all the minerals and oils and gases underneath. Little bit of land. A lot of times in townhomes, they may have a little pad or patio out back. That's theirs too. Little bit of land. More than condo owners. And they own the air above. That's why you can't stack townhomes. Questions so far? Right. So let's take a break. When we come back, we're going to finish unit 2, and then I'm going to introduce you guys to some math. So if you don't have your calculator in front of you, you may want to grab it. So let's take 10. How we doing? Are we still giving 2 thumbs ups or are we? Okay, good. By the way, if you're new to Zoom, it won't be too long where you'll be communicating like out in the real world. So I go meet friends for dinner. I see them. I'm like, hi. I never waved before until Zoom, but now I'm like, hi. And they're like, why are you waving at us? We're sitting right here. So you'll do it too. And your friends will be like, that's kind of weird. Just tell them you're Zooming. All right. We're back. Cameras are on. Again, I got somebody on as a phone number. I don't know who you are. I can't give you credit. So we need to talk. So I make sure. And remember, we're not supposed to be calling in on our phones unless we can communicate with Lane or I.
So this is actually Ariana. I'm here on camera, but my audio is like lagging. So it was kind of
Perfect.
easier for me to hear if I dialed
Perfect.
in.
Could you tell me that in a chat, please? So when I'm doing attendance later, I'll remember that. And I'm gonna
Yes,
ask it
I
again.
sure will.
Will you just shoot me a chat that I am 336 da 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 da? Thank you.
Yes.
I'm telling y'all, my little brain, and it gets littler and littler the older I get. So, help me out. Thank you. All right, so we've taken attendance. And we talked about townhomes. Still in our common forms, our common community interest properties, hybrid forms of ownership. Another type of hybrid form of ownership that we have is, thank you, timeshares. You guys ever heard of timeshares? Timeshares are a form of hybrid forms of ownership. So here's a couple things about timeshares to know before we start writing down every single word. With a timeshare form of ownership, you own exclusive rights to a unit for a certain period of time. So for example, if you have ownership in a timeshare, you may have that right to live in that unit for 1 week out of the year. And it's the same week, year after year after year. So in other words, you own property with 51 other people. Everybody has the right to access that unit. The basic definition of a timeshare says it's the right to occupy a unit during at least 5 or more separate time periods over at least 5 years. So in order to qualify as a timeshare, you have to be able to go there at least 5 times over at least 5 years. I need you guys to note the words at least. At least is the minimum. You can't call it a timeshare if you have the right to go there 3 separate time periods over 3 years. Everybody hear what I'm saying? 5 is the minimum. With the timeshare, with this definition right here, if it meets the definition, then it qualifies as a timeshare. So even if you call it Wilmington's Vacation Resort, and the word timeshare is not in there whatsoever, if it meets this definition, then it falls under a timeshare and the regulations of a timeshare. And guess what I'm trying to tell you is, if it walks like a duck and it quacks like a duck, it's probably a timeshare. Despite what it's called, despite the name of it, if it meets this definition. We do have something called the North Carolina Timeshare Act to help regulate timeshare owners. Historically, buyers, purchasers, again, have felt that timeshare developers could be that shady salesman. There's occasions that they feel that they've been duped into the purchase. And so the Timeshare Act is set up to protect the public. Timeshare developments have to be registered with the North Carolina Real Estate Commission. They're registered, they're regulated, they're observed by the commission. Remember what we said the commission's main purpose was? To protect the public. So even though your ownership interest is for 1 week out of the year, you still have an ownership interest that the real estate commission feels should be protected. Pretty fair, right? So we have our basic definition, at least 5 or more separate time periods over at least 5 years. The purchaser of a timeshare unit has a 5-day recession period, which means once we go under contract, they have 5 days to rescind their contract. If they put down any deposits, they'll get their money back. Again, if we're rescinding a contract, we're putting the parties in their original position. It's almost like it didn't happen. Poof, it's gone. Both parties go back in their original position. So 5-day recession period. And then with timeshares, the timeshare developer, the deposit that the buyer puts down is going to go in the timeshare developer's escrow account. And we're going to talk about escrow account, also known as a trust account. And there's regulations on how the escrow account, real estate commission regulates how the escrow account is handled. We will get to it. But right now, just understand the escrow account is like a separate holding place just for deposits. And the timeshare developer is required to put the buyer's deposit in their trust account for 10 days. If the buyer rescinds in 5, they take that money from the escrow account, refund their money back. If after the 5 days the buyer buys, then on day 10, the developer can take that deposit, move it to their operating account, and use it for their day-to-day business. This is what we need to know about timeshares. Y'all want to do a little exercise together? If you're awfully close to your computer, push back a little bit, give yourself some room. So I don't want you to punch your laptop over or something, right? This is what we need to know about timeshares. Y'all ready? Remember this: 5, 5, 5, 10. Y'all want to do that with me? Didn't it look like fun? Let's do that together. 5, 5, 5, 10. And you know what? Let's throw some jazz hands in, just because it's always better with jazz hands. All right, let's try that one more time. What do we need to know about timeshares? 5, 5, 5, 10. Jazz hands. You won't be tested on jazz hands, but it is fun. This is what we need to know about timeshares. We're going to touch a little bit more on them. Actually, the absolute last thing that we talk about is a little bit more on some timeshares and some definitions. Let's almost think of timeshares as our bookends. You know, we're at the end when we talk about timeshares again a couple months from now. So timeshares, the first bullet point you're looking at is the basic definition. And again, regardless of what you call it, if it meets this format, it's regulated under North Carolina as a timeshare. Another thing about timeshares that makes them unique, one thing we're going to learn, NCREC, by the way, is the North Carolina Real Estate Commission. The Real Estate Commission typically can't fine a licensee. If you violate license law or commission rule, if you violate any of the Real Estate Commission's rules, they're not going to fine you. They're going to discipline your license. The North Carolina Real Estate Commission giveth you your license, and guess what? The North Carolina Real Estate Commission can taketh it away. The unique thing about timeshares, this is the only time that they can fine a licensee. And when it comes to timeshare developers, they can fine the developer up to $500 per violation. So unless you're in timeshare development, the Real Estate Commission can't fine you. All they can do is regulate your license, suspend them, revoke them. We're going to talk about the disciplinary action eventually. We're getting there. Whole lot to say between now and May 23rd. By the way, if you injure a party, a buyer or seller, they can file a complaint at the commission to investigate and see what they want to do with your license. They can also hire an attorney and sue you. The court can fine you. The commission cannot. So could you get fined? Boy, you've really messed up, haven't you? Could you get fined? Could you get sued? Sure, but it's from the court, not the commission. This is what this whole class is about. I don't want y'all to get fined. I don't want y'all to get sued. I don't want you to lose your license because you violated license law or commission law. That's what this is all about. Once you get your license, I want you to be able to keep them. Fair enough? Okay. So timeshares. One more thing left to say in Unit 2, and this is just about trusts. And a trust is just estate planning. Individuals leave their estate in a trust, which basically spells out what you're going to have happen to your estate when the individual passes away. So legal arrangement, which means we're going to call who? We're going to call our attorney. The grantor is the person establishing the trust, setting up the trust. The trustee is the attorney that's handling the affairs on behalf of the grantor. And then the beneficiary is the one that's going to benefit from the trust when the grantor's estate is over. Some people choose to set up a trust as a way to avoid probate. Probate is that legal process of giving up somebody's assets after they pass away. And if you don't know, probate can get costly, it can get expensive, it can get ugly. And so trust may be one way for heirs to avoid that. If you and I are ever called to deal with a property, maybe we're called to list a property that's in a trust, we're going to be dealing directly with the trustee. We're going to be dealing directly with the attorney. So the good news here is we already have attorney involved. We good? That gets us through Unit 2. Again, you guys, those key terms, remember, pre-licensing 101, know what the word means. If you look at those lists on key terms on page 20 and you don't know what the word means, look it up in the back of your book. Don't forget you got Google. So if you don't know what the word means, look it up. Use it as a checklist. There's a nice key point review at the end of each unit, kind of summarizes the whole unit. Kind of use that as a checklist too. We can go through and say, yes, I know this, I get this, I understand that. I'm not sure about that. That's what I need to go back and review. And then of course you got that student quiz. In this case for Unit 2, it is on page 47. I think if I could sum up Unit 2 in 3 words, call an attorney. That's what we just learned from Unit 2. Does that make y'all feel a little bit better about Unit 2? Again, a big part of this class is teaching you to stay in your lane. Y'all have got to stay in your lane. I'm not an attorney. I'm not an appraiser. I'm not a home inspector. I'm not a general contractor. I'm not a surveyor. I am just a real estate agent. So teaching you to stay in your lane and not going outside, not coloring outside of the lines. Everybody good? Thumbs ups? Good, 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 good. I'm going to stop sharing my screen just for 1 second. Y'all hold tight. Don't go anywhere. So you guys can like see each other again and wave at each other. And I'm going to give us just a very brief introduction to math. We're not looking in the book yet. We'll actually start doing math from the book next week when we get to the end of Unit 3. But I just want to introduce you to some of the math concepts that we can expect to see. And I have a math tool that I use that I like a whole lot, that I want to introduce you guys and see if I can't get you on board with it as well. So just a brief math introduction. A couple things. I know some of us like math more than others. Remember what we said on day one, you guys. You're not preparing to take a math test. You're preparing to take a real estate exam with some math in it. So the math is not going to consume all of our class time. The math is not going to consume all of our study time. I understand that we all learn math differently. I understand that we all see math differently. I'm going to offer, when we do math, I'm going to offer, in most cases, several different ways. If you find a different way to do it from me and you get the answer right, great. Anybody remember back in high school? You remember back in high school? And did you ever get points deducted from your math test? You got it right, but you didn't work the problem the same way the teacher did. Anybody else ever get points deducted? Did that make you madder than anything else? You get it right, but you didn't do it my way, so it's wrong. Urgh. Guess what? We're past that. I don't care how you get to the right answer. Just get to the right answer. So I'm going to try to show you a couple different ways as we go through the math in each section. If you like it my way, great. If you find another way, fantastic. Makes no difference to me. I don't need to see your work. All I need to see at the end of the day is A, B, C, or D. So when we're doing the math, let's just kind of introduce you, talk about some basics here. We're going to deal with percentages a lot in this class. And when we're talking about percentages, all we're just saying is that a percent just means per 100. So we're talking about percentages, we're just meaning per 100. So for example, if we say, dang, if we say 5% of the homes on the street are yellow, that just means 5 out of every 100 houses are yellow. The other 95 houses are blue or red or white or gray or whatever. 5% of the streets that we're just saying is 5 out of 100. I've been doing math tutoring longer than I've been doing pre-licensing, post-licensing. I think I'm on like year 13 of math tutoring. And hands down over the years, when real estate candidates come to me, help with math, probably one of the biggest things that I hear is, I don't know how to interpret the problem and put it into math, right? Because we don't read math, right? We do math. And so we're reading this math problem. We're like, how the heck am I supposed to put this into my calculator? How am I supposed to put this into a math problem that I can work? So one thing I want you guys, as we introduce you to the math next week, one thing I want you to start really looking for in a math problem, when we have the word of in a math problem, I'm telling you to multiply. So start looking for that word of. If we know what some of these smaller words mean, then that'll help us take the words and put it into a formula, put it into our calculator. So for example, 350,000 times 25% is the same thing as if we were to say 25% of 350,000. What's the word of telling me to do? It's telling me to take 350,000 and times it by, multiply it by 25%. So why don't you guys, with your calculators, if you haven't been calculator shopping yet, that's fine. You can use your phone today. But please remember to go calculator shopping. Why don't you guys tell me in a chat, what is 25% of 350,000? And again, when I ask for things in the chat, I'm looking to hear from everybody. Class participation. If you don't know, tell me, I don't know. It's about participation, not about right or wrong. Okay. We in and we're finishing up. Understand, you guys, remember the other day we talked about going calculator shopping and getting a basic calculator. The calculator on your phone is a lot smarter than the calculator you can use for your test. This is why I want you to go calculator shopping now, so you can get in the habit of using this one. We're all used to using this calculator on our phone, right? This thing's a lot smarter than this. So please, 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 if you haven't been calculator shopping yet, go. And on your calculator, your not so smart calculator, when we see the word of, that's an indicator to tell us to multiply. So we're going to take 350,000 times, what is it, 25%. And that gives me 25%, 87,500. Your smart calculator, you could probably say 25% times 350,000. This doesn't know how to do that. So this is why I want you guys to go calculator shopping this weekend. Anybody have their basic calculator yet? Let's see those hands. Yep, good. If you don't, please go this weekend. If you're calculator shopping, or if you're on Amazon, if you're not sure if it will work, just shoot me a message. Send me a picture. Say, Julie, is this allowed? I'd rather you check with me now than me tell you no on test day. What do you guys think? Okay. So we took 350,000 times 25%. So now that we know what we know, let's look at, not an actual problem, but let's just look at something more realistic. So we're told that Lane sells her home for $250,000, pays her real estate agent's firm a commission of 5% of the sales price. What is the total commission paid? Again, you're answering this in a private chat. And remember what that word of means. So tell me in a private chat, what's the total commission? I like your first answer better, Dan, but yeah, unfortunately. Okay. So here's a couple things. When you guys see a math problem, that's not true. When you see any test question, any problem, stop and read. Just read the question. When we see math, we see numbers and we want to grab our calculator and start doing, slow down. Take a big deep breath, sit on your hands if you have to, but just read the question. Good advice for any test question. So we've already read it. Lane sells her home, 250, pays the agent's firm 5% of the sales price. That of gives us our formula. So what we're saying is the sales price of 250,000, the word of meaning multiply. So times 5%, and that gives the firm a commission times 5%. Yeah, there it is. Of $12,500. That word of is telling us that we need to multiply something by something. So start looking out for those, start paying attention to those words. Yeah, me too. You'd sell one house and retire, wouldn't you? Unfortunately, you need to sell a few more than that. So 5% of the sales price. Questions so far? By the way, that 12,500, that is not your commission. That's your firm's commission. How much of that 12,500 are you going to get? We'll talk about that in Unit 8. All about your commission, how you get paid, what that looks like. That's what we call fun math. Commission math is fun math. Yes? Yes. You guys tell me, y'all blow my mind. Y'all tell me, I hate math. I can't do math. I'm telling you what, you get in the business and a commission-based business, and you're going to get to the point, somebody's going to call you and say, yeah, I'm interested in your listing on 123 Main Street. And you go and you look it up and you see how much commission you're offered. And while you're still on the phone, you'll be able to calculate in your head how much you're going to get paid when you sell 123 Main Street. So y'all don't tell me you can't do math, because when it comes down to your money, oh, y'all are all over it. As you should be, yes? Yes. So everything you've ever want to know about your commission is coming in Unit 8. So now I want to introduce you to my favorite math tool for this class. And this is something called the T-bar. So let me give you guys just a minute to jot this thing down, and then we're going to talk about what it looks like. So please write this down. So this is my friend called the T-bar. Some of you like it, some of you don't. If you dig the T-bar, great. If not, there's other ways to do it. I encourage you guys to at least try. And the reason I say that, I'm a very firm believer. If you can get the T-bar, I'm thinking you're going to get about 80% of this math. Again, I just kind of made that number up. But if you can get the T-bar, a big chunk of the math in this class is going to be able to solve the T-bar. Now, we have other math that the T-bar doesn't work for, in which case you guys have a formula that you just have to memorize. Knowing the formula is the majority of the battle. If you don't know the formula, you don't know what to do with those numbers. I suggest right now you guys take a piece of paper in your notebook, a blank piece of paper in your notebook, and real big, you write the word formula across the top. And each time I introduce you guys to a formula, you write it on that piece of paper. So when we get to the end of the class, you have all the formulas together on one piece of paper. Everybody with me? Just a suggestion. I also suggest every time we do math, you put those formulas on flashcards. So you can memorize that formula. You can quiz yourself over and over and over and over and over again until you can spit it out. Again, if you don't know the formula, you don't know what to do with those numbers. Memorizing the formula is well more than half the battle. So far, so good? Okay. I get asked all the time, the day before the test, do you have a piece of paper with all the formulas on? I'm telling you guys, you need to do that. I could make one for you, but what good does that do you? You guys need to know those formulas. I already do. So when we can use the T-bar, we're looking at three pieces. We have three parts. There's the part, the whole, and the rate or the percent. Let's talk first about this rate or percent. Anytime we have a math problem with percentage or rate, the rate or percent always goes in the bottom right. Did everybody just hear my absolute word? What does always mean? Is there wiggle room to always? Every single time, the rate or percent goes in the bottom right. You guys don't have to stop and ask yourself, where's the percent go? Julie says the rate or percent always goes in the bottom right. More often than not, when you're reading a math problem and you see the word rate or percent, we can throw down a T-bar and we can put our rate or percent in the bottom right. Or if that's what we're solving for, we know that's our X. That's the easy one. The other two pieces are the part and the whole. Generally speaking, when we're looking at two numbers, part or the whole, the part is going to be the smaller number. So when you have something like, for example, sales price and commission, which number is generally going to be smaller, unfortunately for us? The commission. So when we're trying to figure out where to put numbers in the rest of the T-bar, we need to ask which number's smaller. I have one example that we're going to get to well later in the class where the part is bigger. Everything else we do, the part is going to be the smaller number when talking about the part of the whole. The lines in the T-bar mean something. The back fourth line means divide. The up down line means multiply. And what the T-bar does, you guys have choices. We can either learn how to use the T-bar, which we're going to look at some examples in just a second. The T-bar gives us three formulas. If I'm solving for the part, then I take the whole times the percent. If I'm solving for the whole, if my X is the whole, I take the part and I divide it by the percent. If I'm solving for the percent, I take the part and divide it by the whole. This one T-bar, this one thing, if you will, for lack of a better word, gives us three formulas. I can solve for the part, I can solve for the whole, and I can solve for the percent. So let's look at an example together. Let's say you're reading a math problem. Let's keep talking about commission. We like commission math. So let's say you're reading a problem and it tells you the sales price is $200,000. The commission rate is, and I'm just making numbers up, 4%. And the question wants to know, what is your commission? So of course the problem's like this long and we may have some distractors and da-da-da-da-da, but bottom line, what do I care about? What is your commission? And by understanding the T-bar and how it works, it allows me to just focus on the information that I need to find your commission. So I've read the problem. I'm going to throw myself down a blank T-bar. Julie says the rate or percent always goes where? Always goes in the bottom right. We don't have to think about it. Just put it there. Then we're left with two variables, commission or sales price. And as we've already decided, unfortunately for us, which number is going to be smaller? Our commission. So that's our X. That's the number on top, leaving the sales price as the whole. I can only solve for one X at a time. I can only have one unknown variable. So I filled in my T-bar. I now know what I need to do. The up-down line tells me to multiply. So to find your commission, we take 200,000 times it by 4%. Some of you guys are on it. Like I said, you know how much you're going to get paid in this transaction, don't you? You are going to walk away with a commission of $8,000 when you sell this home at $2,000 for a 4% commission. I solve for X. Now your other option is to memorize the formula. Sales price equals commission times commission rate. Excuse me. Sales price times commission rate equals commission. We're going to use the T-bar, and I just ask that you guys try. Some of you get it, some of you don't. And I do really think it's a good tool if you try. Less formulas you have to memorize. And again, I do think this helps with the majority of the math. So let's do a what if. What if we're on the test day, we're at the heat of the test. Test stress is a very real thing. And you read the test question and you have no idea what to do with those numbers. After all your months and months of practices, you read that question, you go, oh my God, I've never seen this before in my entire life. First off, stop and breathe. Take a big, deep breath. Julie says the rate or percent always goes where? Always goes in the bottom right. Even in your height of test stress, the rate or percent always goes in the bottom right. So now what we're left with is the other two variables. And now we're sitting there going, oh, which number goes on top? Which number goes on bottom? Oh, I don't remember. Yes, do I have a quick question?
I was just letting you know that my computer died and it got me off and I got back on.
Welcome back. Thank you.
Okay, thank you.
So we're in the heat of the test. We don't remember which number goes on top, which number goes on bottom. We do remember the rate or percent goes in the bottom right. One thing I like about the T-bar, I call it Julie proof. Like I can't even mess this up despite how much I try. In all my years of math tutoring, probably the hands down, the number one question I get, when do I divide and when do I multiply? And my highly educated response to you is do it both ways and see which one works out for you. Instead of staring at a blank piece of paper and waiting on numbers to like magically appear, just do it both ways. So we put the rate or the percent in the bottom right. And now we don't remember which number goes on top, which number goes on bottom. So in order to answer that question, we're going to try dividing. Why don't you all remember this back fourth line here means divide. So now to solve for X, why don't y'all tell me in a chat, when we take 200,000 divided by 4%, what's your commission? And yes, you're seeing that right. Yes, you're seeing that right. You guys seeing what I'm seeing? By switching those numbers, when do I divide? When do I multiply? When you take 200,000, we're going shopping, aren't we? We're going to buy a jet, an island, buying it all, aren't we? You take 200,000 and divide it by 4%, you are getting a commission of $5 million. Woo! Does that seem reasonable? Does this make sense to sell a house for 200,000 and make a $500,000 commission? My point is, you guys, if you're never sure whether to multiply or divide, my highly educated response to you is to do it both ways and see which one makes sense. Rate or percent always goes where? Bottom right. Play with those other two numbers if you need to. That's right. That's right. If multiplying doesn't work out for you, try divide and see how it gets. And for the most part, we could easily say, that's not right. Clearly, my commission is $8,000. Perfect. If you like to do the 0.04, perfect. Yep. However you see that. Some of you like the percent key. Some of you want to convert the percent to a rate. Perfect. Did you get $5 million? Then you did it right. And that's what we're looking for, is that right answer. So now, everybody good? Everybody have this? Everybody with me so far? So now knowing what we know, we already know the answer to this question. I'm not looking for the answer. Now knowing what we know, let's look at this problem again. And I'll give you just a second to try the T-bar. And you don't have to tell me in a chat. I'm just giving you a second. Because we already know the answer. I just want you to use the T-bar on your scratch paper. Did you guys get the T-bar on your paper? Did you get the same answer you got the first time? We know we're off to a good start, right? So we saw the math problem, we read the math problem. I saw the word rate or percent. Usually when we see the words rate or percent, more often than not, I don't know anything else, but at this point I know I can probably throw down a T-bar and do something with it. First thing to plug in is that rate or percent. That's the given. You don't have to think about that. You don't have to question that. It is 5%. Now we got a sales price and a total commission. Total commission is the smaller number. Sales price is the bigger number. Up, down line means multiply, which means we take 250,000 times 5%. Another way of saying 5% of the sales price. And that gives us our commission. What was it, 12,500? That gives us our commission. Brief introduction to the T-bar. We're actually going to put it into place next week when we get to the end of Unit 3. I'll talk about what next week is going to look like before we leave today. So if you need to leave early, please make sure you look at the recording, the end of the class today, so you can know where we're going to be next week. I'm a big fan of the T-bar. Big fan. Learn that about me now. Now that we know the T-bar, there is a formula. You're not going to be tested on it, but I do want to show this to you guys because I think this will help you guys in grading yourselves. When you're taking the quizzes at the end of each unit, we need to make sure that you repass. Again, 75% is the bare minimum. I would shoot for 80, 85. I think one of you earlier said you wanted to go for 100. 75 is the minimum. I think anything over that to give yourself some wiggle room. So let's say you take the quiz in Unit 2. We can use the T-bar to help you get your score. If we look at the number you get right as part of the total number, let's do that, total number of questions. That's going to give you your score. So right out the gate, we can use the T-bar to help gauge ourselves as we go. You guys have got to be grading yourselves as you go. You've got to know how you do in Unit 2 before you get to the test. You've got to know how you're doing in the different units. If you guys are grading yourselves as you go, there should be no surprise on test day. So please make sure you're practicing this. So let's say we take the quiz at the end of Unit 2. Unit 2 quiz, there's a total of 25 questions. And let's say of those 25, you got 18 right. And what you're solving for is your score. On your calculator, you say 18 divided by 25. And you get a score of 0.72. Move that decimal over 2 places to the right to get your score of 72%. Did you pass Unit 2? No, you're close, but you didn't pass Unit 2. Do you need to go back and review Unit 2? Do you need to spend some time studying those questions that you missed? This is what we mean by grading yourself as you go. Your calculator gives you a rate. You convert the rate to a percent by moving your decimal over 2 places. Score 72%, again, is close, but we need you to go back and look at it again. Okay, how am I doing so far? Do I have any Insta T-bar fans? Yeah, yay, yay. For the rest of you, don't worry, I'll get you. I'll get you. Don't worry. That's like my personal goal each class, to have y'all walking away going, wow, the T-bar. So we're actually going to use it in practice again next week when we get to the end of Unit 3. We're going to put it into real play. But I just wanted to introduce you to it, kind of get you to start thinking about it before we get there. That math facts section in the back of your book that we looked at on Tuesday. Let's see. Page in here, it talks about converting rates to percents. But if you guys look on page 786, like really quick, 786, it kind of gives you another demonstration. They call it the X bar, T bar, same thing. So you can go through, remember I'm recording. So if you want to go back through this little section, if you want to get a head start on some other ways of how the T-bar can work. Guys, let me say this about math too. We do math. We don't read math. So when you guys are going through these exercises, do you see like the examples, 786 and 787? Don't read that. Pick up your pen or your pencil and your calculator and your paper and do it. If you can do it in your own style, in your own writing, it's going to mean more than reading it. We good? Okay. It's break time. So let's take 10. We come back, we're jumping into Unit 3. Anybody still working on coffee? I go all morning. I can knock a pot out by myself. Easy. My husband told me once we couldn't afford a Keurig. He's right, by the way. All right. We're back. Cameras are on. Thank you guys for being back on time. We kind of get in the flow of the class, kind of getting the idea of how things, that's kind of what I like about the first couple of days, may take some of those guessworks out. So yeah, I mean, this is pretty much us. We'll throw some games in. We get to play a game next week. Doesn't that sound like fun? We'll work some math, but pretty much we're just plucking away at this material. So I need you guys to hang on to your hats, and I need you guys to commit to studying outside of class so you can get this stuff. Hearing it once in class in 75 hours is not enough to get you to pass. So we got to commit. We're going to start studying this weekend. Oh yeah. Okay. Y'all please remember, never hesitate to reach out to me if there's anything I can help with. If I can help unclear anything or help you figure out why they think a question's wrong. That's why I'm here. So with all that being said, I'm taking attendance. So everybody can say cheese. Y'all start posing and I love it. Okay, so I catch myself usually on the screenshots. I'm talking. Maybe I should stop talking every once in a while. All right, moving right along. We're jumping into Unit 3. And practically everything that we talk about in Unit 3 is an encumbrance. So we're going to talk about obviously what an encumbrance is, and we're going to talk about encumbrances and how they affect real property. So the theme of Unit 3 is all about encumbrances. So our roadmap, before we can have this conversation, we obviously need to define that word. So we're going to explain what an encumbrance is. Under encumbrances falls something called a lien. And there are a couple different types of liens. So we're going to talk about those. We're also going to talk about the different types of easements and how those work. And then we're going to get into property taxation laws. So we're going to talk about how North Carolina handles property taxation. We're also going to talk about how other states may handle property taxation. And one thing we have to look forward to is our first real map. So at the end of Unit 3, we're going to teach you how to calculate property taxes and how to determine your annual taxes, your assessed value, your tax rate, all that good stuff. So as we said, the theme to Unit 3 is an encumbrances. So let's first talk about what the heck an encumbrance is. An encumbrance is just anything that affects the title to real estate. They're not necessarily good. They're not necessarily bad. They just affect the title. Encumbrances are almost always appurtenant. And what does it mean if something's appurtenant? It runs with the land. So almost always, if somebody has an encumbrance on your property, it means that they have a right or an interest. They're not the owner. They don't have an ownership interest, but they have some kind of right, maybe permission to be there, maybe to collect an unpaid debt. So if someone has an encumbrance, they have some type of right or interest. Again, most everything, there's only like one thing in Unit 3 that's not an encumbrance that we'll obviously address when we get there. But most everything else is an encumbrance. So the first encumbrance we're going to talk about, and the one that we find on most properties, are liens. When you guys see the word lien, I actually want you to see the word loan. If you have a lien on your property, that means you owe somebody some money. Where are my homeowners on the call? Where are you guys? There you are. Hi. We'll get to renters too. Don't worry. We'll talk about you guys as well. Most of us, there are some exceptions, I understand, but for the most part, when we buy a home, we have to do so with the assistance of a lender. Unless you're a cash buyer, you're going to have to get a loan. If you're a cash buyer, then good for you. The rest of us have to go through a lender. We have to get a loan. So the day you buy your house, if you're getting a loan, probably before you get the moving truck in your driveway, you're going to have a lien on your property. And that lien is going to be that loan from the lender. It's a charge. There's no possession. The lender doesn't hold title to the property. But they have a lien. They have an interest in the property because they are owed money on that property. So anybody that you owe money to may have the right to file a lien to protect themselves to get paid. We're going to talk more about liens. Let's just back up for 1 second. Has anybody ever sold a house before? I know who my homeowners are, but has anybody ever sold a house before? Anybody sold a house? Few of you? Good. When you sell your home, there's a whole line of people standing in a certain order waiting to collect from you. You owe them money, you owe them money, you owe them money, you owe them money. So they're all standing there in line. The lien holders are all standing in line waiting to collect from you when you sell your home. The homeowner is actually the very last person in that line. When you sell your home, you get whatever's left. Liens are going to be recorded. They're going to be down at the public records at the Register of Deeds down at the courthouse. By putting them on public record, we can notify the whole world, I can't transfer this title until I pay these liens. Again, we're going to talk all about recordation and when we get to Unit 5. So we have two different types of liens. The first type of lien is referred to as the specific lien. It's called a specific lien because it's specific to the property. Specific liens attached to the property, not the person. So if for some reason this is missed by the closing attorney, and this lien isn't found and this lien isn't paid, it's appurtenant. It attaches to the property, which means the next person that owns the property is stuck with your debt. Does that seem fair? No. That's why we record at the courthouse. That's why we have closing attorneys to make sure before you convey, before you sell your home, that all those liens are taken care of, because it's specific to the property, can only affect and attach to the property. The deed of trust is your mortgage. North Carolina is very fancy. We don't call it a mortgage, we call it a deed of trust. We're going to talk all about your mortgage, your deed of trust. I got 2 units dedicated to financing. So when we get to our financing units, but when you go to a lender and request money to purchase a home, that deed of trust becomes a specific lien, which means it attaches to the property. Your real property taxes. We are assessed, we pay real property taxes every single year. Every single homeowner, property owner, I should say, every single property owner in the state of North Carolina pays property taxes. If we have any government special assessments, a special assessment is taking money for a specific purpose. So the reason that a government, or reasons that the government might issue a special assessment, maybe they want to install sidewalks or street lighting, or maybe they want to hook a whole neighborhood up to public sewer or public water. They may put a special assessment on those homeowners to allow everybody to share the cost and that improvement on the property. So government special assessments are specific liens. Mechanics liens are specific lien. Hang on to mechanics lien just for 1 second. We're going to talk a little bit more about that next. And then we also have something called a North Carolina commercial real estate broker lien. And what this lien does is it may give the commercial real estate agent the opportunity to file lien on the property to protect their commission. Commercial only, Residential, we can't do that. So these are specific liens. And again, in just a bit, we're going to talk about something called lien priority. But one thing I want you guys to go ahead and start thinking about right now, our real property taxes and our government special assessments. Is that superior? Superior. I told y'all I can't spell. Our real property taxes and our government special assessments are referred to as superior liens. If they're superior liens, who do you think is going to get paid first? The government. Makes sense, doesn't it? The government makes the rules. The government's going to make sure they get paid first. I can't blame the government. If Julie made the rules, do you know who would get paid first? Julie, absolutely. So your real property taxes and your government special assessments are your superior liens, meaning they will get paid first. When we talk about lien priority, they are the first ones standing in line when with their hand out when you go to sell. So putting specific liens off to the side for just a second, let's have a conversation about this mechanics lien and what this means. Mechanics liens are regulated by something called the North Carolina Mechanics Lien Law. The whole point of the mechanic lien is to offer security for those that provide labor or supplies in the improvement of your real property. If you hire somebody to come to your home, your property, and do work, and you don't pay them for doing that work, they have the right to file the lien down at the courthouse to protect that interest. They're giving themselves a place in that line. Why don't you guys tell me in a chat, who do you think of when we think about a mechanic? Who is somebody that might come on your property and provide labor? Or offer supplies, something in the improvement of your property? Yeah, we got some good stuff coming through. So who is considered a mechanic? Let's see what we got. The floor man coming in to put flooring in, general contractor, I'm seeing that, the handyman, the HVAC guy, the carpenter, the plumber, the electrician. My father, the contractor, yep, roofing. There's electrician again, construction crew, like to build a deck, absolutely. The HVAC guy, new roof, architect, if we're going to design something. Digging a well, the electrician, the landscaper. Paving company, we're putting a driveway in. Yeah, AC guy, sub guy, painter. All these are people that are providing labor or furnishing materials to improve your real property. You hired them to do a job. You didn't pay them when the job was complete. Don't they have the right to try to still get paid? Don't they have the right to collect? And that right that they have to collect is by filing a mechanics lien on. So with the mechanics lien, there's just a quick, the mechanics lien law says any project we're doing, may that be commercial or residential, if the project's more than $30,000, then we have to have a designated lien agent. And what I mean by that is we have to have somebody that's dedicated to oversee the operation of the project. If we're doing an improvement that's $30,000 or more, we got several subcontractors involved, right? Maybe we got to pay the drywall guy and the electrician and the plumber, right? There's several people coming in. So this lien agent is the one person that kind of oversees the whole process. And the lien agent is responsible for making sure that all those subcontractors get paid. The exception, a good exception to most rules, Anything that's owner occupied would be exempt from this. So in other words, if you're a do-it-yourselfer and your project's more than 30,000, then you wouldn't have to hire that lien agent. So there's some rules for the mechanics. They can't just file a lien on you whenever they want. There's some rules for mechanics. And the mechanic lien law says that the mechanic must file that lien within 120 days from when they last offered the labor or the materials. So whatever day the job ends starts their 120-day clock. They may send you a notice, a bill. They may send you a reminder, right? 30 days, 60 days. And if they start feeling like you're not going to pay them, then they go down to the courthouse within 120 days, file the lien, and that reserves their right to collect. If they don't file the lien within 120 days, they've lost their right to stand in line as a lien holder. They can still send you threatening letters, right? They can still do all that, but they've lost their place in line with the lien priority. The mechanic's lien also gives the mechanic the right to bring action to enforce. By that, we mean foreclose. Anybody you owe money to can foreclose on you. Ouch. You owe $400 to the landscaper and they can foreclose on you. Anybody you owe money to can start the foreclosure process. So if they're going to bring that action to enforce, they have 180 days from when the work ended. So it all starts, both of these clocks start from when the work ends. 120 days to file the lien, 180 days to bring action to enforce. Now, guys, let's be really honest. You're a landscaper that you didn't pay is probably not in the foreclosure business. It's a lengthy process. It can get expensive. It may not be worth them to foreclose on you for $400. They may not actually do it, but the point we need to get is that they can. But they have this small period of time, this 180 days to do that. Do you have to do the lien prior to foreclosure? I don't think so. I don't think it's first and then that, right? I think they can do both. They can do one or the other. Okay, so let's talk about this lien priority. Remember all those people that are standing in line waiting on you to sell your house so they can collect from you? Everybody's standing in line, and lien priority tells us what order they're in. Who's number one, who's number two, who's number three, who's number four. We said superior liens are always paid first, right? So if you didn't pay last year's property taxes, they're standing in line first. If you have any outstanding government special assessments, they're standing in line second. Superior liens are always paid first. All other liens after that are paid in the order in which they're recorded. So basically, the first one to get down to the courthouse with their lien tells us the lien priority. All liens are paid in the order in which they're recorded, except for the mechanic's lien. The mechanic is not paid in the order in which the work recorded, in order in which it was recorded, excuse me. The mechanic is paid in the order in which it began. So it goes retroactive to the start date. So where is your mechanic with that outstanding lien? Where are they in that lien priority? It depends on when the work began. Superior liens are paid first. All liens after that are paid in the order in which they're recorded, except for the mechanic's lien that's paid in the order in which the work began. We're going to look at an example together. I like pictures, remember? Everybody have this so far? So let's walk through a couple scenarios. You'll put your pencils down for a second. Let's walk through a couple scenarios together. Let's say on August 8th, your water heater goes out. Mechanic comes, fixes or installs a new water heater, leaves, you never pay him. Do you owe that mechanic? That mechanic provide a service, provide an improvement on your home. Hot water's nice, isn't it? So they offered a service. You don't pay them. They have 120 days from when the work began to file the lien. Now, we're not getting into semantics here, but roughly speaking, 120 days would be 4 months later. So they have their deadline to file the lien is December 8th. If they choose to take action to foreclose, their deadline to do that is February 8th. So we have 120 days from when the work ended, 180 days from when it ended. This scenario, it started and ended on the same day. So we have a little timeline. Let's say August is a really bad month for you. And 2 days after your water heater goes out, your AC quits. Son of a gun. So your AC goes out on August 10th. AC guy comes out, completes the work on the 16th. They have 120 days from when the work ended. So it ended on the 16th, which means their deadline to file the lien is December 16th. Their deadline to take action to foreclose is February 16th. The 120 days and the 180 days is from the time that the work ended. So the AC guy files the lien on November 20th. The water heater guy files the lien on December 1st. They're both within their 120 days, right? So we're good. They've secured their place in line. Why don't you guys tell me in a chat who's going to get paid first? AC or water? Who's going to get paid first? Remember, we're looking to hear from everybody. You got a 50-50 shot here. So who's going to get paid first? Our brains want to tell us it's the AC guy because they filed their lien first, right? That's not the way mechanics lien work. Mechanics lien is not paid in the order in which it's recorded. It's paid in the order in which the work began. Which mechanic started their work first? The water heater guy. So who's going to get paid first? The water heater guy. Mechanics liens are the only liens not paid in the order in which they're recorded. They are paid in the order in which the work began. So again, lien priority. We're going to talk a little bit more about it. Lien priority says superior liens are going to get paid first. All other liens are going to get paid in the order in which they're recorded, except for the mechanics lien. They'll get paid in the order in which the work began. It's retroactive. It goes back to the work started. Didn't this mechanic show up on day one? Maybe it takes them a couple weeks or a couple months to complete the project. But did they show up and start working on day one? Didn't they bring supplies? Didn't they have labor on day one? So it gets to go retroactive back to when the work began. They started supplying you labor and supplies the day they pulled the truck in your driveway. Questions? Cool. So specific liens attached to the property. Specific liens are pertinent, which means if they're not paid at closing, they stay with the land. They run with the land. Big responsibility of our closing attorneys is to make sure all liens are found, addressed, and taken care of before the seller conveys the property to the buyer. We want the buyer to start with a clean bill of slate. Yes? Let's do a what if. Let's have fun. Let's do a what if. Okay. Let's say you are a buyer's agent. You're helping a buyer buy a house. And you go under contract, and your buyer wants the seller to do repairs. The buyer asks the seller to do repairs. Now, one thing we're going to learn in North Carolina, sellers aren't required to do repairs. Sellers aren't required to fix anything. So we can always ask. There's no rule that says we can't ask. Buyer asks the seller to do repairs. The seller says, sure, I'll do repairs. We're about 2 or 3 weeks away from closing. Seller agrees to do the repairs. Seller has the repairs done. Seller doesn't pay the mechanic. We go to closing, and under 120 days, the mechanic files the lien on the property, which is now owned by the buyer, or let's call them now the new owner. The unsuspecting new owner, unbeknownst to them, this lien is put on their property because the seller never paid for those repairs that they agreed to do for the buyer. Whoa. What happens now? If a lender's involved, the buyer is required to purchase something called title insurance. And title insurance is meant to protect the new owner for stuff just like this. Things that we couldn't find when we searched the public records. The mechanic didn't even file this lien until after closing, right? It happened like 2 weeks before closing. They still had 3.5 months before they could file the lien. So the buyer, if a lender's involved, is required to buy title insurance. If it's a cash buyer, it's highly recommended. We're going to talk about title insurance in Unit 5. Unit 5 answers the question, what the heck does the closing attorney do? And that's what we're going to address in Unit 5. I just don't want you guys to fear for that poor, unsuspecting buyer. There are things in place. Can sellers be, and buyers too, be dishonest sometimes? Do people lie sometimes? Unfortunately, yes. So we have things in place to help protect owners, particularly those new owners. So we'll talk more about this when we get to Unit 5. Specific liens are specific to the property. The other type of lien we have are called general liens. These attach to the person. And they're going to follow you everywhere you go. Anytime you apply for any kind of loan, home loan, car loan, any kind of loan, they're going to follow you until they're paid off. If you go to sell your house and you have a general lien, those lien holders get to stand in line with their hand out. It follows the person. It does not attach the property. So some examples of some general liens. A judgment is a lien issued by the court. You guys see the word judge in that? Judge, judgment. The judge has put a lien. Maybe you have unpaid child support, for example. They may issue a judgment on you, which means that follows you everywhere you go until you get that paid off. Personal property tax lien. We pay personal properties or personal property taxes on, the cars, the boat, the RV, the jet skis, the motorcycle, all of our toys, right? We have personal property taxes. Failure to pay those personal property taxes would result in a general lien. State tax liens, if you have any unpaid income taxes, or maybe a state inheritance tax, Did you know they tax you when you inherit property? They're going to get you every which way, you guys. So you inherit property, there may be a tax. Failure to pay that could result in a general lien. And then our federal tax liens would be like your unpaid IRS taxes. So general liens attached to the person, specific liens attached to the property. All lien holders, once they file that lien, once it becomes public record, that gives them the right to stand in line to collect. There's a whole bunch of people that are excited on closing day. Lien holders are one of them because they're getting their money. Again, the very last person in that line is the seller. The seller gets whatever's left after everybody else has been paid. There are situations where the seller's underwater, which means they owe more than what the property's worth. We only have so much money to give out. And when we run out of money, there may be some people there at the end with their hand out that aren't going to get anything. We're going to talk about that. We're going to talk about how that looks, how they can collect possibly later, what the seller can do in that situation, what it looks like for them, all in due time. HOA liens, if the HOA, they may file a lien as well. That would probably fall under, I would think general liens. I don't know that for sure. But yeah, anybody you owe money to can file a lien. Moral of this story, pay your bills, pay those people off. Don't be in this situation. Before we talk about lien priority, we mentioned that homestead very briefly back in Unit 2. We're going to mention it very briefly here again too. Again, just kind of a blip. The homestead could fall as a general judgment lien. That's all we're going to say about homesteads. If I were a betting woman, I'd say this is the last time you see homesteads. But it's in the syllabus. I mentioned it, satisfy the criteria. We're moving on. So our lien priority, here it is. Superior liens are always paid first. Superior liens are your real property taxes and your government special assessment, not HOA special assessments. Your government special assessments. All other liens after that are paid in the order in which they're recorded, except for the mechanics lien that's paid in the order in which the work began. Lien priority, again, answers the question, who gets paid when you sell your house? Questions on liens. Lien equals loan. You owe somebody some money. Good stuff, isn't it? Another encumbrance that we may see on properties are our restrictive covenants. Covenants are what we see when we're in an HOA. It's a private agreement between the homeowners association and the homeowner. Restrictive covenants are pertinent, which means what? They run with the land. They run. Yep, they run, however you want to remember that. Restrictive covenants are created by the developer. Because they're pertinent, they remain once the developer's done developing and they move on to a different community. So when we're done building, when there's nothing else left to build, the covenants remain. We're going to talk a lot more about covenants in Unit 6. It's been my experience, people are either for them or not. And when I say not, I mean like not even a little bit. If you're working with a buyer that doesn't like the idea of covenants and being in an HOA, then don't show them property that's in that HOA. If they're not sure, help them understand. Again, we're going to talk more about these covenants when we get to Unit 6. Some covenants are more restrictive than others. Some are pretty loose. They're all different. So when we're helping a buyer buy, we want to try to get those covenants in their hand so they can review them, so they can see the rules of the subdivision and make sure they're good with them when they buy. Some of them will tell you like whether or not you can have a fence, if there's a certain placement of your mailbox, if there's a certain shade of blue your front door can be. Some may tell them how high your grass in the front yard can be. Some are more restrictive than others, but what we need to get is they're all different. So more on covenants in Unit 6. Again, what we're knowing right now is they're an encumbrance. They affect the land, they affect the property. Something else that could affect the property. Here's your Latin lesson for the day. A lis pendens. This is Latin for pending litigation. This is a notice. It's recorded at the courthouse. It's public record. A lis pendens is a legal stop. And what the lis pendens is saying, do not buy this house because there's some ongoing court proceeding, some ongoing legal action happening right now. And if the owner, due to result of this court case, due to the result of the court case, at the end of the court case, if the court takes the property, it's no longer the seller's to sell. Can you sell what's not yours? No. So what this is saying is, stop. Do not buy this property until this court battle is over. We know the outcome and we know who the rightful owner is and whether or not they can sell it. So it's down at the public courthouse, it's public record. Another legal warning is referred to as a writ of attachment. With a writ of attachment, there's been a court order to seize the property. Isn't that cool? The writ of attachment is a court order to seize the property. Again, it's a legal stop. Don't buy this property because the sheriff's on their way to take this property, take control of this property. Again, you guys, it's a legal stop. If the judge is going to seize the property, they're not going to go take it, are they? They're going to send the sheriff. Again, just a legal stop, a legal warning, trying to protect the unsuspecting buyer. Yes, Sydney.
What would cause this to happen? Why? I've never heard of this before.
So we're going to talk about why the judge or the court may take properties. We're getting to that in Unit 5. So we'll talk a little bit more about some of those reasons why.
Thank you.
Of course. You guys can't hear the mower out here, can you? Speaking of grass in the front yard getting too tall. Whew. Mine's out here taking care of it right now, and I'm so glad. It's like a jungle in my front yard. Luckily, I'm not an HOA that fines me for every day that my grass is over X amount, because I would have gotten lots and lots of tickets. Yeah, right. Another type of encumbrance, something else that encumbers a property, is an easement. Have we heard of easements? We may not know what it is, but have we heard the word? Yep. With an easement, you have permission to use the land of another. You have permission to be there. You have no ownership, but you have permission to be there. I don't know many properties, including yours, that don't have some type of easement. Let me ask you guys some questions, and you can raise your hand. Yes, hand up means yes, no hand means no. So let me ask you some questions. Do you guys like electricity? Do you guys like water? Do you guys like your internet? All of that has reason to be there because of an easement. They have permission to run their lines, their poles, their equipment, whatever they need on your property to provide you with the water, the electricity, and the internet. All of you just told me that you like. Does this make sense? I don't know many homes, not unless you're way out in the middle of nowhere and you're living off the land and doing your own resources. Maybe you don't have an easement, but I think for the most of us, we have some type of easement on the property. Again, there's no ownership. It's just permission to be there. We have two types of easements. The first type of easement is called an appurtenant easement. What does this easement do? It runs with the land. It's appurtenant. So it goes from one owner to the next, to the next, to the next. Appurtenant easements are always and only two tracts of adjacent lands. They're side by side, they touch. Appurtenant easements are always and only two tracts of lands. And what makes them appurtenant? They affect both titles. They affect both tracts of land. So two tracts of land side by side, touching, and this easement affects both. Let's name both of these tracts of land. Both tracts of land have a name. We have the servient tenement and we have the dominant tenement. The servient is the one being used. The servient in which the one in which the easement runs over. The dominant is the one doing the using. Let's look at a picture. You guys look with me on page 56. On page 56, we have two tracts of land, lot A and lot B. For some reason, I don't know why, but for some reason, this must be like a protected tree save that lot B has, meaning they cannot cut down those trees and build their own driveway. So the only way that B can access the road is to drive over A's land. Everybody see that? The only way they can come or go is by driving over A's land. A is the servient because their land is being used. B is the dominant because they're the one doing the using. More often than not always, but just as an example, more often than not, the reason these become servient and dominant, let's say you have a tract of land. Right, you have a tract of land. Here's the road. And you have this tract of land. This is the parcel of land. And one day this homeowner wakes up and he says, you know what? I'm going to subdivide my land and I'm going to make it into two tracts of land. So now we have lot A and lot B. A has got to grant B permission to cross their land to get to the road. We can't landlock somebody. Landlock means preventing somebody going onto or coming off of their land. So if A or whomever decides to divide the land, we may create an appurtenant easement to give B access to the road. I actually showed B one time. I showed this house back here, and the driveway was right here on the edge. The driveway was owned by A, but B had to access it to get to it. Who owns the driveway? Whose property is that on? Isn't that on A's? Who's responsible for maintaining it? Who's responsible for paying taxes on that portion of the land? It's the owner. Now, can A go knock on B's door and say, hey, our driveway needs repaired. You want to go in on this? Sure, you can always ask. There's no rules that say you can't ask. Is B under any obligation to help pay those repairs? No, because they don't own that land. They have no ownership interest whatsoever. They have an easement. They have permission to drive over A so they can come and go from their property. Pertinent easements, always and only 2 tracts of land. Servient in this case would be A, they're the one being used. Dominant in this case being B, they're the ones that are doing the using. That's a good example. Why? Thank you. These easements, how do we know about them? How do we know exist? Well, they're recorded. They're down in public record. So before you buy, your closing attorney should pull up. Your closing attorney should know. Help let you know. You got to go over somebody's land to get to it, to access it. Pertinent easements affects 2 and only 2 tracts of land. With easements, not really a type of easement, but just something that could go along with easements. Here's that party wall again. These sometimes can be referred to as cross easements. These guys have a shared driveway. They both have permission. They both have an easement to share, to both drive on that driveway. They even got a party wall in their garage. You guys see this back here? Their garages share that party wall. They got all sorts of cross easements. Best bet when it comes to these is to have these in writing, just to protect both parties. Again, kind of an easement. Not much else we're going to say about that. So the first type of easement is a pertinent easement. A pertinent is how many tracts of land? You can all show me. How many tracts? Always and only 2. And they're pertinent, which means they run with the land. The other type of easement that we have is something called an easement in gross. An easement in gross, again, a couple different types. With an easement or gross, the right belongs to one individual or one entity. There is no dominant tenement. There is no one person benefiting. This easement benefits the user. And we have a couple different easements in gross. You could have a personal easement in gross, which means you grant permission to somebody to access to use your land. Personal easement in gross, or any easement in gross, excuse me, any easement in gross does not run with the land. They're not a pertinent. So when you sell, the easement dies there. Let's say on your land, you have a really nice pond and you have a friend that wants to come fish on your pond and they want permission to come fish on your pond whenever they want to. They don't have to call and ask. They just want permission to show up whenever and fish on your pond. They may ask you for, or you may grant them a personal easement in gross and give them official permanent permission to come fish on your pond. When you sell your property, that personal easement in gross dies. If your friend goes on the property after you sell it to fish on the pond, they're now trespassing because they don't have permission to be there anymore. The other easement in gross, which I think is the one we see the most often, is the commercial easement in gross. This is like Duke Power having permission to have power poles on your line, on your property. R&R Railroad having permission to run train tracks on the back part of your property. Commercial easement in gross can affect one tract of land. It can affect thousands of tracts of land. It benefits Duke Power or R&R Railroad because it allows them to use your land. If Duke Power were to close their doors, I think we'd have bigger problems than easements. But if Duke Power were to close their doors, this commercial easement in gross would die with it unless it's transferable in whomever's buying Duke Power. Good attorneys will make that happen, but it's got to happen. It's not automatic. So if Duke sells to Julie's power company, Julie's attorney is going to make sure that I get that easement. Does that make sense? It doesn't happen automatically. Our picture on page 57, again, lot A and lot B. You can see there we got some power pole lines. Really affects lot A much more than it affects B, doesn't it? But doesn't it also affect B? Aren't those power pole lines touching their land? So easement and gross, again, no, the only person benefiting is the person that has the easement, the person that's doing, using the land. Every once in a while, for example, you hear, it shows up on the news where somebody, tried to fight the city or fight Duke because they said, I don't want Duke employees on my land. Well, they have an easement. They have the right to come on your land to service their poles or to service their train tracks or whatever. That's what the easement is. They have permission. They have a right to be there. It has to transfer. So if the owner dies, that means that Duke shuts their doors, right? That's how an entity dies, right? They close their doors, they shut down shop. So if Duke dies, then it's got to be transferred. It doesn't happen automatically to the new power company. Again, that's why we have really good attorneys. Or Duke does. Duke can afford a much better attorney than you and I can, can't they? They got it. Or whomever's buying Duke, I guess. I'm gonna say one more thing. Actually, you know what? No, stop. I'm gonna stop here. Okay, don't go anywhere just yet. Hold up. So we're gonna end here, which means we're going to pick up when we come back. Let's see. What if we want to build something on the land that Duke is on? It's your land. You just can't tear down their power poles, right? So if you want to build something around the power pole, whatever, they may have some kind of something in the easement that says so many feet from the pole, but that doesn't give you the right to run out there and chop down their pole. That pole is protected by that easement. All right, next week, everybody remember, no class on Tuesday. Can I see more head shaking? Yes, please. No class on Tuesday. Okay, so we will see each other again. We just met and we already get a week off from each other. We will see you guys again next Thursday, 1 week from today. What a great opportunity to give you guys a chance to get caught up. If you've looked ahead or if you haven't looked ahead and you're not in Unit 3 yet, what a great opportunity to start. If this is brand new information that we don't have class on Tuesday next week, you already have 4 hours set aside to study, don't you? Because you thought you were going to be in class. So maybe you still do your thing Tuesday from 9 to 1, but no class on Tuesday. When we come back together on Thursday, we're going to pick up on page 57. We're going to get through Unit 3. including the math. If you guys will real quick, skip ahead to page 63. Any unit that has math in it gives you an introduction to the math called these math concepts. So you guys may want to look ahead at the math concepts about property taxation, the things that we're going to do. Again, when you see, for example, do it. We don't read math, we do math. So when you look at these math concepts, the 4 examples, kind of get yourself exposed to the math that we're going to do on Thursday. After unit 3, we're going to get into unit 4. Unit 4 is really short and sweet. We're going to get through it quickly. After unit 4, we're jumping into unit 5. I suspect us to get into unit 5 on Thursday. So again, I'm asking you to look ahead at least through unit 5. If you're already that far, keep going. We're eventually going to cover it. Guys, please remember to look at that tentative schedule and the online learning system, because I don't go in order of the book. So if you guys are looking ahead, you're looking at the tentative schedule to know about what I'm going to cover when. But please use this opportunity next week to get yourself caught up, to get yourself to where we are. Like I said, once we get through unit 6, give me about another week or so, 2 weeks or so, and we're going to start getting into some heavily tested stuff. So get your study habits down, get yourself caught up. You guys with me? Get, in the habit of studying and committing and devoting. Guys, it's all about finding balance. I'm not telling you to give anything up. Of course, you're going to spend time with your family. Of course, you're going to work. Of course, you're going to watch a show on Netflix. But I need you guys to find the balance to incorporate study time into your already busy lives. If you guys figured out by now, I pretty much just gave you a part-time job, didn't I? So please use this time to fit it in so you can do it all and be successful in this class. I'm trying to be very transparent with you guys. This is a tough class. These are tough tests. And I need you guys to commit today. I don't know another way to say that. Is that fair? As far as I'm concerned, you guys paid good money to be here. So let's make good use of that money. Let's put your all into it. Good? Good. I look forward to hearing from the rest of you, your homework assignments, if I haven't met you yet. I look forward to hearing from you guys. Otherwise, y'all have a great week. Let me know if I can help in any way. And we'll see you guys. We'll start at 9 a.m. next Thursday. Thank you.
See you next week.
Have a good week.
You too.
I just wanted to let you know, I don't know what happened. My internet